Thank you, Honorable Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction on Appeal from the Court of Appeal of Guyana. Hearing of appeal in CCJ application GYCV number 4 of 2020 between Merlene Todd and Desiree Price and Ann Jennifer Jeboo. This morning's 5-member bench comprised their honors. Honorable Mr. Justice Witt, presiding judge.
Good morning, counsel.
Good morning,
Honorable Mr. Justice Anderson.
Good morning, counsel.
Honorable Mr. Justice Barrow.
Good morning, counsel.
Honorable Mr. Justice Burgess.
Good morning, counsel.
And Honorable Mr. Justice Jamadar.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please your honors, I, Manoj Narayan, appear on behalf of the appellant, Ms. Merlene Todd. Ms. Merlene Todd has joined this hearing via the video link provided.
If it pleases your honor, my name is Juman Yassin. Associated with Mr. Tini Husti, we appear for the first name respondent, Desiree Price.
Okay, thank you very much. Before we start, just a practical question. We do not seem to have the judgments of the Court of Appeal. In this case, we have transcripts. I also read in those transcripts that the judgments would be available within, I think, a week or so, but I have not seen them. Is that correct? They have not been produced?
That is, sorry. That is correct, your honors.
Okay. Have there been any attempts to to get those judgments, or?
I have personally made more than one attempt, your honor, as recently as a few weeks ago.
Okay. Okay. Well, thank you. Well, anyway, we have the transcripts. So I think we can proceed. I think Mr. Narayan, it's you are the one to start here.
Very well, your honor. May I proceed, your honor?
Sure, and you will be reminded, of course, of the time limits that we impose. 60 minutes.
Thank you, your honor.
And that's a maximum.
Good morning, your honors. May it please your honors, my presentation this morning will fall under 4 broad categories, namely the issue of fraud as governed by Section 22 of the Deeds Registry Act, Chapter 5:1, the use of the fraudulent power of attorney and its effect thereon on the issuance of the transport, the issue of negligence, and the power of an appellate court to set aside vary or overturn findings of a trial court. I will commence with the issue of fraud, your honors, which is the gravamen of this case. And in Guyana, the relevant section is Section 22 of the Deeds Registry Act, which is taken to have been read by all. It is this important section that must be deconstructed and analyzed. And the first sub-issue I wish to deal with under the issue of fraud is the jurisdiction of the court to set aside a transport on the ground of fraud. I humbly submit that there are limitations contained in the very Section 22. One such limitation is that the action for fraud must be brought within 12 months of the discovery of the fraud. And the second limitation is that the court only has the jurisdiction to set aside or declare void a transport in the hands of a person or the holder of that transport who is either a party to or is privy to the fraud. That is what the section says. So in the instant case, the transport is in the hands of the appellant, Ms. Merlene Todd. It has been there since prior to the institution of the proceedings in the High Court. And as a result, the jurisdiction of the High Court to set aside and declare void that transport can only lawfully be activated and invoked upon an action against Ms. Todd on the basis that she, as the holder of that transport, was either a party to or a privy to the fraud. An action was commenced against Ms. Todd and one Ms. Jeboo. However, that action, I humbly submit, does not activate and invoke the jurisdiction of the court under Section 22, since there is no pleading or allegation of fraud against the holder of the transport, whether as a participant in or privy to that fraud. So it is my respectful submission in this regard that the High Court was without the power to set aside that transport in light of the fact that the pleadings never invoked that jurisdiction. And in this regard, I wish to go straight to the trial judge's ruling on this issue, and that is Chief Justice Mr. Ian Chang, sadly now deceased. And at page 14 of His Honor's judgment, His Honor stated as follows, and I wish to quote very briefly. This court has noted, and I quote, "This court has noted that in the statement of claim, the plaintiff never made the allegation that the first named defendant, who is Todd, was privy to any fraud. Indeed, the allegation made against the first named defendant by the plaintiff, Price, in the statement of claim was that the first named defendant, Todd, was guilty of negligence. Yet, outside the statement of claim, counsel for the plaintiff has urged this court to find that the first named defendant was privy to the fraud of the second named defendant. In other words, counsel has sought to step outside of the pleadings. This is impermissible without amendment." So the Chief Justice declined the jurisdiction to set aside this transport, so to speak, on the basis that there was no allegation or pleading of fraud. And this brings me to the second sub-issue, which regards the pleadings in this case.
Before you go to the second sub-issue, counsel,
Yes,
could I ask, you had indicated at the beginning that there were two bases on which the fraud could be pleaded to nullify the transport. First, it had to be brought within 12 months, and then the holder of the transport would have to be a party or privy to the fraud. We didn't say anything about the first criterion, the action being brought within the 12 months. Are you conceding that that was satisfied in this case?
Yes, please, Your Honor.
Okay, thank you very much.
And okay, now the words party to or privy to the fraud which was committed by Jeboo, that's not in so many words in the claim, in the statement of claim. It says about Ms. Todd that she contributed to the passing of the fraudulent transport by negligently failing to take certain steps. Is that not another way of saying that she was somehow conducive to the fraud? Or would you say no, that would go too far?
No, please, Your Honor. I do not hold that opinion, given decisions that have come from this very court regarding the requirement of pleading of fraud, including in the Jairam case, in Subhas, Ramdeo, and Hiralal, and others. And I will get to those. There must be a specific allegation of fraud. That is what the section requires. It is very clear. The section is not ambiguous in any way. It says that the transport is liable in the hands of the holder.
Sure.
Provided that that person is either a party to or privy to. Privy in the sense that they had knowledge of the fraud. And I will come to what is meant by this fraud in this particular case.
Yes. But we agree that there was a fraud in the sense that Ms. Jeboo well, she had a power of attorney that was apparently forged.
I agree. I agree with that there was a fraud committed by Ms. Jeboo.
But you say, okay, but that's not enough. Your client should have been party to that fraud, or at least have known or be privy to. I think we will get to the interpretation of what means privy to. But that wasn't said with so many words in the statement of claim.
No, and that is my contention, that she was not a party to or privy to that fraud.
Yeah.
May I proceed, Your Honors?
Sure.
Yes, please.
Grateful, Your Honors. Your Honors, with regard to the issue of the pleadings in the case, as Justice Witt has just identified, it is clear that the issue of fraud must be clearly and adequately particularized by way of pleadings. And I wish to cite in support of that contention the cases of Ramdas and Jairam, a decision of this court, which is reported at 72 West Indian Report at page 270, and also the case of Wallingford and Mutual Society and Official Liquidator, 1885 appeal cases at page 685. Your Honor, in the High Court proceedings that were instituted by Allan Price, neither in the endorsement or statement of claim is there any specific allegation of fraud against Ms. Todd. The allegation is one of negligence. And I'm humbly submitting that this is not sufficient for the purpose of setting aside a transport. This honorable court, time and again, has strictly enforced the principle that fraud must be specifically pleaded and specially proved. As recently as in the case of Kwang and Yoki, this honorable court agreed with the approach of the trial judge, again happened to be Mr. Justice Ian Chang, who refused to allow the testimony of a valuation officer called by the plaintiff on the basis that there was no pleading to support that evidence. In essence, this court agreed with the position that the plaintiff should be unable to lead evidence of fraud that was not specifically pleaded and particularized in the statement of claim. And more particularly in regard to this case, I am referring to paragraph 38 of the decision, reported at 2016-88 West Indian Report at page 339. Previous to that, in the case of Ramdas and Jairam, the appellant in that case had alleged that the transport was passed fraudulently by both of the respondents, but he provided no particulars of fraud. In fact, at the hearing of the action, the issue of fraud was altogether withdrawn. Before the Caribbean Court of Justice, it was advanced that the court still had the power, in the absence of such particulars and pleading, to go ahead and to make a finding on the issue of fraud. And this court had no difficulty in rejecting that argument. And in the case of Subhas Rambio and Hirilal, reported at 2009 CCJ3, this honorable court, the decision of this honorable court was delivered by the Honorable Mr. Justice Hayton, and at paragraphs 53 and 54, Justice Hayton stated as follows, and I quote, "In a democratic society where the rule of law prevails, it is fundamental that if a plaintiff seeks to establish a factual basis for allegations that the defendant defrauded him, he must, in his pleadings, specify precisely the nature of the allegations upon which such very serious charge is founded, and set out full factual particulars to justify such allegations. No such matters as those raised above were pleaded and particularized, so the respondent and the co-defendants could justifiably expect not to have to meet the charges of fraud. The judge himself was not in a position to make any findings as to fraud. The appellant, via his then attorney, only has himself to blame for this." And these were the words that were approved and by this honorable court in that case. So I'm humbly submitting that for the purpose of Section 22, and given the nature of fraud, fraud is not strictly a civil cause of action. It is almost quasi-criminal in nature because it can attract criminal penalty. And that has always been the jurisprudential rationale and justification for the requirement that fraud must be specifically pleaded and specially proved because a defendant must get the opportunity to respond to those allegations. If no such opportunity is given to a defendant, some injustice may be suffered by him.
Counsel,
Yes, please, Your Honor.
aren't you spending too much time on the pleading aspect? Because I think everybody accepts that fraud was not pleaded in relation to your client.
Very well, Your Honor.
The Court of Appeal, I think, came to the conclusion, notwithstanding that, they accepted it was not pleaded in relation to your client, but they said that fraud was pleaded against Jeboo and that it was pleaded that your client contributed to that fraud and therefore was, as it were, infected by fraud, but that there was not any pleading of fraud against your client, I think is a given.
Very well.
Having spent 15 minutes so far, and since you intend to take up your full 60, perhaps you may want to move on from that.
I will definitely take the guidance of this court and move on, please, Your Honor. Your Honor, I will move to the issue then of what is the fraud that was committed in this case. And the Section 22 provides that the court has the power to set aside the transport in the hands of any party who is either a party or privy to the fraud. Your Honor, in this case, it is undisputed that the fraud that was committed by Jeboo, and the singular fraud is that of the forging of the power of attorney, or alternatively, the series of acts in a singular transaction, that is, the procurement and registration of the fraudulent power of attorney. That is the fraud that has been committed in this case. That is, in fact, the case of Price in the High Court on the particulars of fraud.
Good.
So it must be shown that Ms. Todd was either a party to or privy to that fraud. That is the only fraud. And I am humbly submitting that that fraud committed by Jeboo was committed way before Ms. Todd came into the picture. That fraud was committed at the time when the power of attorney was executed and registered. At that time, Ms. Jeboo was nowhere in the picture. She was not around. When Ms. Todd went to the office, when Ms. Jeboo, along with Nalini Singh, went to the office of Ms. Todd, that power was already produced. And Ms. Todd, yes, please.
I have found it very intriguing that the power of attorney was signed off by, as you put in your submissions, no less an eminent functionary of the court than the deputy registrar, who said that Mr. Price came before him. I do not see any discussion given to that apart from in your submissions in any of the judgments or, in any of the judgments or the transcript. Is there anything more that we know or that can be said in relation to that? Because the success of the fraud, the success of the forgery, it seems to me, pivoted entirely on the deputy registrar saying that this is a genuine signature of Mr. Price. So is there anything more?
Well, Your Honors, at the time when that power was presented for registration to the deeds registry, the fact that it was notarized by Mr. Rashid Mohammed was declaring to all the world to see that, or to say that Mr. Price appeared before him, and right. Mr. Price produced that ID card and signed this document in his presence, that he was satisfied as to the identity of Mr. Price, that Ms. Jeboo also appeared and signed, and he was satisfied as to her identity. And therefore, based upon that, the power was accepted by the deeds registry. And the clerk to the deeds registry, the legal clerk, who gave evidence in support of Ms. Price in the High Court, said that Mr. Mohammed's signature is very familiar to her and that she instantly recognized that signature as being his signature. And Your Honor, that is a very important point that the Court of Appeal did not at all examine. When Ms. Todd went to the deeds registry and she saw that this power of attorney, or she discovered rather, that this power of attorney was executed by none other than the deputy registrar, she may have let her guard down. She may have told herself, well, if the deputy registrar has notarized this power, there is no other searches that I need to do. I can safely go and deal with this transaction because of who notarized it.
I understand your point, but I think Justice Barrow also hinted at the fact that if it is true what you're saying, then it means that the deputy registrar had been saying untruths, because you say this whole thing didn't happen. Mr. Price never went to Guyana during that day, that time, and so it cannot be true what the deputy registrar confirmed. And if that is so, it's a little strange that that is hanging around without any more. You're basically saying that what the deputy registrar confirmed was untrue, wasn't that so?
Well, it eventually turned out to be untrue.
Yeah.
It turned out to be untrue. At the time,
Counsel,
yes?
It's not that it eventually turned out to be untrue. It was from the start untrue, which is remarkable. So I'm asking if, in terms of the evidence, I'm not asking you to give outside information or anything, but in terms of the evidence, is there any indication that any inquiries were made in relation to how could this be and what is to be done in relation to such a manifestly false certification? I'm just curious.
That issue was not explored in the High Court at all, Your Honor.
All right, you can move on then. Thanks.
As we have raised the issue of the power of attorney, Your Honor, I would like, however, to point, Your Honors, to a section. Forgive me, it was not quoted in my submissions, but I only dealt with it after I received additional authorities from counsel for the first named respondent. And the section that I would like to quote, Your Honor, it is from the Deeds Registry Act, Chapter 5:01, and the Deeds Registry Act deals with the registration of all deeds, including powers of attorney. And Section 8 of that Act says, and I quote, "The book of all registers or records heretofore existing in the office of the Registrar of the Supreme Court or any branch thereof shall be taken to be and are hereby declared to be valid and legal records, and all authentic copies thereof or extracts thereof shall be received in courts of law as prima facie evidence. If not rebutted, shall be good evidence of the originals." Your Honor, when the sections of the Deeds Registry Act are examined, Sections 8, Sections 7(2), and the rules of the Deeds Registry rules, and those rules are Rule 4, 23, and 24 are examined, the legislation ought to be interpreted in such a way that the power of attorney is valid until it is declared to be invalid or until it is revoked by a court or by the donor. That is the way the law seems to be set up in the Deeds Registry Act. So although the power of attorney was fraudulent and forged, the fact that it was registered in the Deeds Registry, having regard to the provisions of the Deeds Registry Act, Ms. Todd was entitled to act upon it, which she did. And she did not have any knowledge that at the time of entering this transaction, that power of attorney was fraudulent. She was certainly entitled to go with what is the state of the law. And the state of the law is that power was valid at the time. She did not know that the power was invalid. Nobody could have known that. Only Mr. Price could have known that. And she went ahead and she entered into the agreement of sale. And it is my humble submission that Ms. Todd is protected by virtue of Section 22 of the Deeds Registry Act because she's not a party to or privy to the fraud committed by Jeboo.
And you would go therefore further by saying that she did not turn a blind eye to anything in relation to the power of attorney that she ought to have perceived or she ought to have been put on inquiry in relation to. That would be your case.
Well, I am saying that after discovering that the power of attorney was notarized by Mr. Rashid Mohammed, there was nothing suspicious arising thereafter because it would have been reasonable for Ms. Todd to proceed on the assumption that this power is valid.
I'm taking it a bit further than you. The extension to your point is that Ms. Todd did not turn a blind eye to anything, that she was not negligent, far less grossly negligent in relying upon the power of attorney because of the provisions that you put and because of the underlying proposition that somebody can rely upon a validly recorded and validly executed, seemingly, power of attorney.
Yes, that is my contention. She did not turn a blind eye. And not only in relation to that aspect of checking the power of attorney, but in regard to her whole conduct in this case. Because she also checked the transport, and it was found to be a genuine copy of a transport. She visited the land and found that it was empty. She inquired about the whereabouts of the original transport, and Ms. Jeboo produced to her an application for her loss gross, which was already prepared and filed by another lawyer. She inquired about the whereabouts of Mr. Price, and she was told by Jeboo that Mr. Price is my uncle, I am his niece, he's overseas. She did not, of course, try to make contact with Ms. Price, because again, at the time, Ms. Price probably would have been thinking, listen, this power is there, registered in the court, notarized by Mr. Mohammed. I don't need to go further. And in Guyana, powers of attorney are widely used because of our rate of migration. A lot of people live overseas and conduct business with powers of attorney. Every year, over 1,000 powers of attorney are registered in a deeds registry. And it is...
Counsel, that is the only point in terms of your submissions which gave me pause. As you're saying, there was no legal requirement on her to do this. But I suppose somebody could say, well, she could have tried to have gotten in touch with Mr. Price. But how do you do that? Because the information you'll be getting as to the whereabouts of Mr. Price would have been coming through Ms. Jeboo.
Your answer is very interesting. And I say it's interesting because when you're dealing with fraudsters, as Ms. Jeboo, they sometimes think everything out. In Guyana, there was another fraud, including a power of attorney and involving a bank, the NBS Bank. And in that case, the fraudster who procured a fraudulent power of attorney told the bank, yes, you can contact my principal in America. And he had a family waiting there to answer the phone and said, yes, I am Mr. John James. And the bank proceeded to release the money based on that power. So when you're dealing with...
I would have thought, with respect, cannot be a good fraudster unless you have thought of these contingencies. So that for you to say, or for anybody to say that, Ms. Todd should have made further inquiries, I think I would need to be convinced of the efficacy of that course of action. And as you said, it seems to me to be quite reasonable that she relied on the power of attorney, which was notarized, as you say. But it does open up a question, which is, well, how does one prevent this kind of fraud from occurring? It's not your responsibility. It's probably not Mr. Houston's responsibility. It might be the responsibility of the regulatory authorities. That there must be some avenue by which, one can make sure that the power of attorney is a genuine one.
That is correct.
it goes beyond our litigation this morning, but I would like very much if some thought could be given to that by the relevant persons in Guyana.
Well, Your Honor, what I will say in that regard is that this case is not the norm. This is an exception.
Ah.
In thousands of cases where powers of attorney are used, this one happens to be the one that ended up with a transport being passed. And the simple answer is that notaries should be held responsible. They are given a very important function with regard to the execution of deeds. And if they're to commit fraudulent acts, they need to be the ones facing consequences. Because in this case, we are left with two innocent parties who are now fighting for the same rents. One will lose, one has to lose, and one will win. One will feel there is an injustice at the end of the day, while one will feel that justice has been delivered. And that is the danger in it. And so at the end of the day...
May I ask you a question? What happened with the order for damages against Jeboo? Because order for $7 million, was it $7 million?
$12 million.
$12 million. And order, the trial judge did find, as against Jeboo, that damages were due and payable, as I'm assuming compensation for what transpired. The appeal never went. Jeboo did not participate, I believe, any further. Has that order been overturned, or does that order remain in effect?
Your Honor, the Court of Appeal varied that order and ruled that both Jeboo and Todd are liable to pay damages to Price in the sum of $4 million. As far as
so the Court of Appeal reduced the amount?
They reduced the amount, having restored the transport to Price.
I see.
They awarded damages for fraud against both Todd, the appellant, and Jeboo. And Your Honors, in the ordinary course of things, this case here took almost 8 years to be heard and determined. And it was during that time that Jeboo was able to slip away. Because if this case had not taken so long, Mr. Price may very well have been able to...
Is it 8 years or is it 16?
Well, 8 years in the High Court.
I calculated 2004 to 2012 for the High Court, and 2012 to 2020 for the Court of Appeal.
Yes, Your Honor. 8 years in the High Court and 8 years in the Court of Appeal.
That's what I'm saying. It took 16 years.
And during which time Jeboo slipped away.
Well, so why not? 16 years is a lot of time.
So as I said, this case is more of the exception. And Your Honor, importantly, when there was a full police investigation, Ms. Price, Jeboo was investigated and the appellant Todd. And Todd was cleared of any wrongdoing. She was not charged. Jeboo was charged in a magistrate's court. There is evidence of that in the High Court, and she was sentenced to 3 years.
She was sentenced in absentia?
No, Your Honor, she was there. She presented herself and pled guilty.
And did she serve time?
She served her time.
I see.
So if at that stage, had there been any kind of collusion between Jeboo and my client Todd, Jeboo could have said, listen, I'm not going down alone. I am telling the court the truth. You're party to this fraud, or you're privy to it. None of that happened. Jeboo pled guilty, and she spent 3 years in jail. When she came out, nobody knows what happened of her. And in the meantime, the case was languishing in the High Court. So Jeboo slipped away. So whatever damages was granted against her, unfortunately for Mr. Price, he was unable to recover. But again, this case, that is more the exception. This should not have been so.
Well, I'm glad it's the exception. I was a bit concerned about the extent of the fraudulent use of the power of attorney. So I'm very pleased it's the exception.
If it wasn't, there would be a lot more cases of fraud, forged powers of attorney addressing or engaging the attention of this court. And Your Honors, if I may proceed now to the issue of negligence. What the Court of Appeal did is that all of the allegations that were made against this transport, and those allegations, when they are examined, they are all related to a mistake in a date or a scratch, an insertion. All of those things are in the nature of clerical errors, either committed by the attorney at law or the attorneys at law clerk who prepare these conveyancing documents. None of these, counsel also paid great attention to the fact that the name Byron Dick was written on the certificate of compliance. Again, when all of those allegations that were used as allegations of fraud in the High Court are examined, they are completely unrelated to the fraud in the case. The fraud in this case is the forging of that power, the procurement of the fraudulent power. None of those things relate to that. And Section 22, when it is deconstructed and analyzed, says that the party must be privy or party to the fraud. No such allegation here that Todd was privy or party to that forging of the power. Ms. Todd herself is the victim. Because, unfortunately for Ms. Todd, if this court...
Was there any evidence that Todd knew Jeboo before this transaction or had any dealings with her before this transaction? Was there any evidence of any prior acquaintance or relationship?
Ms. Todd, in her evidence in the High Court, says that she'd never met Jeboo. The first time she met Jeboo was when Jeboo came to her office with the real estate agent. That was not disputed or challenged. In fact, Ms. Todd's evidence as to what happened from the beginning of the transaction to the end was the only evidence in the court, because Jeboo was not there and Mr. Price died. So it was Ms. Todd's evidence that it was completely unchallenged. And the court accepted it and found that she was a bona fide purchaser.
I believe there is one other issue on which the allegation of fraud was also based, that had to do with the disparity between the market value of the land and the purchase price.
Very well.
That was raised. Did you want to respond to that?
I will respond to that, but thankfully, Your Honor also reminded me of another issue. Mr. Yassin, in his submissions, indicated that Merlene Todd ought to have examined the signature of Price on the transport which was presented to her by Jeboo as against the signature on the power of attorney. And had she done so, she would have seen a disparity and she would have been put on alert. That is not the case. The transport that was issued or given to Todd by Jeboo contained no signature of Allan Price. It is that very transport that Mistress Price tendered into evidence at Exhibit D, I believe it was. And if the court, and it is to be found at, if the court will just bear with me, it is to be found at page 120, I believe, of the Record of Appeal. Yes, it is to be found at page 120 to 122 of the Record of Appeal. That was the transport that was given to Merlene Todd. That is the transport which Desiree Price tendered into evidence at the trial. It does not contain the signature of Allan Price, and I will ask this court to examine it. The transport that contains the signature of Allan Price is the transport, the original that is lodged in the deeds registry, and that was produced by Gita Anirudh during the trial. Gita Anirudh was a legal officer at the deeds registry. And that transport is exhibited at Exhibit N in the trial and is to be found at page 137 to 140. So it is completely erroneous to say that the transport given to Todd had Price's signature. That was not so. Even the transport that Desiree Price had in her possession didn't have Allan Todd's signature. And I move on out to the point that was raised by Your Honor regarding the valuation. Your Honor, it is true that a valuation was prepared and tendered by Mr. Hugo Curtis, which shows that the value of that property was $12 million. In her evidence, Ms. Todd also had a valuation prepared. It is referred to both by counsel in his submissions in the High Court and in the ruling by the Honorable Chief Justice in his written decision. That valuation showed that the market value for that property 11 years later was of a lower sum, $9,200,000. So although both of those valuation officers worked with the same department, the Government Valuation Office, one says that the property was valued $12 million in 2004. The other one says the property was valued $9.2 million in 2011. That is the disparity in the evidence regarding the valuation. But more importantly, In Guyana, during that period, 2003 to 2004, I was a law student at the UG, University of Guyana. There was a serious crime wave in this country. This country was closed down. Students were not able to go to school. Persons were migrating. Those who had properties were selling it out so they could migrate. Because they were freedom fighters, they call themselves freedom fighters in this country. And they were terrorizing and killing people wantonly. It was during that period that Ms. Todd bought this property. And Mr. Hugo Cortes, sorry, on the cross-examination admitted that it may very well have been possible that the price was lowered in order to achieve a quick sale during that period. Or the price was lowered because the principal was overseas and he didn't want to come back to Guyana during that period. So it was priced to go quickly. And that of itself is not fraud. Getting a bargain is not a fraud. I did not do something improper or dishonest. I did not do something unconscionable if I jump on a bargain. So
Yes.
with regard to the
I hear you. Of course, it's quite a bargain to go from the higher valuation of 12 million to purchase the property for 4. But I would agree that that in itself might not be indicative of fraud. I think what the other side would probably say is that that would help to put your client on quote unquote notice that something amiss may have been going on.
Your Honor, if deals are not available in real estate would have no money. And as we all know, real estate is one of the industries that has the most money. Buying, selling, flipping properties. There are always deals in real estate. And
I think the standard expression was he got that at a steal.
And Ms. Price is a businesswoman. She stated that she owns several properties. In her evidence.
I'm not really want to adopt my brother's way of characterizing it at a steal.
that is a colloquial term, but it didn't mean that Ms. Todd stole the property.
Right.
When the evidence is examined in this case, as I am sure the court would examine it, and the conduct of Ms. Todd is examined, she did all that she could have done as a reasonable and prudent buyer. Under our laws, there is nothing more that is required of her. She did all of the searches. Counsel for the respondent sought to introduce a line of cases, starting with Oliver and Hinton, to say that Ms. Todd should have done more. Those cases, I've examined them in my submissions, what they deal with, and they are completely, the principles from those cases are completely unrelated to Section 22 of our Deeds Registry Act. I have stated in my submissions what are expected of a prudent purchaser of land in Guyana, and Ms. Todd followed all of those steps. She verified the documents, she visited the property, and she made all possible inquiries. In addition to that, before paying the balance of this purchase price, it is a requirement for the vendor to obtain a certificate of compliance from both the Mayor and City Council and the Guyana Revenue Authority. It is undisputed that it is the norm and practice in Guyana that those documents are only issued by those agencies upon the production of a valid form of identification of the principal. So how was it that Ms. Jeboo able to get these documents in the absence of having an identification card? All of these are issues that were not examined by the plaintiff in the High Court. There was no cross-examination to these issues, cross-examination. When the evidence that was led in support of this case of fraud is examined, it is my submission that evidence falls way, way short of what is required to establish a serious charge of fraud, and especially having regard to the wording of Section 22 of the Deeds Registry Act.
The issue of the advertisement for the passage of transport, no difficulty was experienced with that. There's no issue taken with that. The regular period for the advertisement was observed, was it?
All the regular protocols, rules, procedures were observed in the passing of transport. The issues that were raised were the clerical mistakes on the documents, conveyancing documents.
No, I'm with you. Again, I'm going to the heart of the matter as you more or less put it, and that is to say that we have two quote-unquote innocent persons, and unfortunately, it seems one will lose. So I'm just trying to figure out what were the opportunities available to each to ensure that their interests were protected. Now, if the advertisement for the passage of the transport was in regular form, that would have given some opportunity to, I assume, Mr. Price
To oppose.
to object, to oppose, yes.
That is correct, but he didn't do so. You see, Mr. Price was out of the jurisdiction for 20 years. It is sad to say this, but Mr. Price, in a way, contributed to that state of affairs because he left his property, an empty, vacant lot, with fraud rampant in Guyana at certain times, and that property was left there unattended for 20 years. That is what paved the way for Jeboo to pull off this fraud. There was nobody looking after that lot for Mr. Todd. There was nobody paying rates and taxes. There was nobody clearing it, weeding it. Mr. Price himself never traveled here, as the evidence stated. It was disclosed that since he left Guyana in 1983, he did not return to Guyana until after the transport was passed, when he returned to file the proceedings. So there
but
is...
Mr. May I ask you a question? The statutory regime or regulatory regime for all of the notarization, the certificates of compliance, the 2 certificates of compliance, the advertisement requirements, all of those things are designed as safeguards to ensure that the system is, I don't want to say fraud proof because this case proves the contrary, but to safeguard the system so that people, if something is happening and a property is being sold, I mean, this is actually, when I read this, I find this very remarkable. In Trinidad and Tobago, nothing like this exists. There is no such requirement for all these certifications or advertisements. If you have what we call it RPO lands, Real Property Ordinance lands, the torrent system, and you can do the transaction straight off. You can set it aside for fraud also, but all of these things aren't required. So that what I find for myself, very impressive is that in Guyana, the statutory and regulatory regime has built in so many layers. As our brother Justice Barrow asked, a deputy registrar, I suppose, reputable notary public, 2 government agencies, as you say, they should see forms of identification before they issue certificates of compliance. That is to say, we are satisfied that the actors are the real thing. How did all of that happen? I mean, I suppose those are the unanswered questions, but I think the system has built in a lot of safeguards. Would you agree with that?
I agree with that. They're all checks and balances because Section 22 is intended to create some indefeasibility of title. That's
22.1. You mean it starts with 22.1?
Yes. Yes.
Exactly. So that to demonstrate that Todd was a party to or privy to fraud, one has to show that in some form or fashion, Todd was invested or a party to all of these little things, the false notarization, getting the compliance certificates in some way. Absent all of that, what is the gross negligence in not doing more to find out?
I think we have to keep in mind that the system is that this is an abstract system of property transfer, as they call it. Going back to Charles V in 1529, that kind of system. In Holland in the 17th century, in the 16th, 17th century, if there was a transfer of land, it would have been mentioned 3 times on 3 Sundays in church. and you still have that in the form of the publication in the Gazette, which used to be on, I think, 3 consecutive Saturdays, etc. So going back to a very old system, it's an abstract system where we don't go back once the transport is there. It is basically indefeasible unless, and there are a few exceptions. And the exception we are talking about here is fraud, which either you are party to, but there is no, as I think it is in agreement that there is no evidence that she was party to, that she was actively involved in the fraud committed by Ms. Jeboo. The question is, was she privy to that fraud, and how do we decide what that is, privy to? So, as the jurisprudence says, you have to have actual knowledge, then you will be privy to, or at best, and that is an if, and maybe we are in that area, what they call in South Africa dolus eventualis, or blind eyes knowledge. That means, well, what does that mean? How far does that go? As I understand it, it means that there are so many signs that there was a fraud committed, and then you deliberately look the other way. In that case, you really didn't know, but you're very close to that idea of privy to. And the question then is, okay, where do we draw the line? And if we draw the line somewhere, is there any evidence for such blind eye knowledge? I think that is the question that needs to be answered. And how do you answer that question? I know how you answer it, but you just be specific.
Yes,
Your Honor, in answering that
if
question.
I may, sorry, if I may, counsel.
Yes.
This is following on from Justice Witt's question. If you go to the Court of Appeals judgment, the Court of Appeal was able to find fraud by, as it were, invoking circumstantial evidence. Well, certainly making certain inferences or drawing certain inferences from the evidence which was produced in the Supreme Court. Now, the High Court, sorry. The question which I want to raise with you is, to what extent can fraud be established by circumstantial evidence?
Very well.
Because that's how the Court of Appeal arrived at its finding that there was fraud.
Yes, very well. If I may proceed to answer Justice Witt's question first. The answer to that question lies in the conveyancing process itself. And this is how the conveyancing process works. I will try to briefly say it. After the agreement is signed, the parties go to their respective lawyers. That is the agreement of sale. The vendor takes his original transport and so on to his lawyer. The purchaser goes to their lawyer. The lawyer is then responsible for preparing all of the conveyancing documents, instructions, affidavits. They will call the clients to sign. Thereafter, the purchaser has nothing else to do other than count her money and wait until the day is fixed for passing of transport in the court. She has absolutely nothing else to do. All steps is then on the vendor to get the matter advertised in the official gazette, to get their compliances from the GRA and the Mayan City Council, and all other steps. So it is the vendor that is tasked with this responsibility. So to answer Justice Witt's question, from the moment Ms. Todd signed that agreement and gave it to her lawyer, she had no other involvement other than to show up on the day of passing of transport with her bag of money, sign and collect her transport. So there was nothing there to show that she was privy to anything else that was transpiring within that time. And the evidence doesn't say so either. There is no allegation, no pleading, and no evidence of any acts that she was privy to this fraud. None whatsoever. And secondly, in relation to the question raised by Your Honor regarding the Court of Appeal inferences, it is my submission that those inferences, those instances that were drawn by the Court of Appeal, they all in some way or the other overruled, overturned, or varied findings made by the Chief Justice in his written decision. And the Chief Justice at least tried to analyze his position. There was no analysis from the Court of Appeal. They simply imputed this circumstantial evidence as evidence of negligence going to fraud, which is a very, very, very long, giant leap to take. Circumstantial evidence as evidence of gross negligence amounting to fraud. That is where the end.
Counsel, if I may, counsel.
Yes.
The Court of Appeal cited its authority to supplant, as it were, the High Court by virtue of the power to draw inferences, to have all the powers of the High Court and so on. Now, how do you respond to that position by the Court of Appeal? Because the Court of Appeal didn't claim to be acting other than outside of the powers which were granted to it by the Civil Procedure Rules and the relevant Court of Appeal Act.
My response to that is twofold. First of all, it was never open to the High Court to set aside this transport on the basis of fraud because it was not pleaded against Todd and there was no evidence of it at all. So the jurisdiction
we've accepted that. We're moving
so
away
therefore, if the High Court,
second question.
If the High Court didn't have the jurisdiction, the Court of Appeal could not have had that jurisdiction under the section which they relied upon, which is Section 7. I did address it in my first set of submissions. And my second answer to that question is that the inferences that were drawn, the cases that were cited, in all of those cases, when those cases are read, an apex Court of Appeal overturned an intermediary court who had previously set aside trial judge's findings. So none of the cases are supportive of their power to set aside the findings of the trial judge unless you can show that the trial judge was palpably in error. Even if you have a different conclusion on the evidence, you cannot substitute that conclusion for that of the trial judge, and that is what the cases say. You must show that in his evaluation of the evidence, the trial judge committed an error, a grave error, by being palpably wrong. In the absence of that, you have no power. An apex court has no power. And that is what all of those authorities said that were even relied upon by the Court of Appeal. So I'm not sure if the Court of Appeal fully read those authorities.
Appeal made reference to some of the authorities.
I did address it in my submissions, my first set of submissions, and I summarized the principles emanating from those cases, even by this very court in one of those cases, Campbell and Narayan, I believe it was. Even the sentiments expressed by this court in Campbell and Narayan is against what the Court of Appeal did. And when you examine the transcript, unfortunately, that's all we're left with. But when you examine that transcript, it lacked clarity. The reasoning of the Court of Appeal lacked clarity. I was confused as to what I was reading. A litigant is expected to know why a court ruled against her. As the lawyer, I was unable to explain to Ms. Todd why this court ruled against her.
I presiding judge this morning was a little bit flummoxed by not having the written judgment, because I think the written judgment would have helped perhaps to clarify the reasons for the decision.
I would have certainly liked to have had some clarity on the reasons myself. I didn't get that from the transcript. Your Honor, unless there's anything further, I believe my time may be taken up. Or how much time do I have left?
3 minutes.
3 minutes. So in conclusion,
you notice I'm paying attention to it.
And you don't need to fill it up till 16.
No.
Very well, Your Honor. That is the extent of my presentation, unless I can be of any further assistance to this honorable court. And I thank Your Honor very much for the time.
Thank you very much.
Grateful, Your Honor.
Mr. Yassin.
Thank you very much, Your Honor, and good morning again. Your Honor, I will be dealing with the facts and some other aspects as regards the power of attorney being void ab initio, and my learned friend, Mr. Hoosty, will be dealing with those aspects of negligence that cross over to gross negligence. and also the aspect, if the court wishes, notice and actual notice, as is with the legal system in Guyana. Your Honor, this case is a most unfortunate case. As we said, two parties are here innocent, and I assume at the moment that Mr. Todd is innocent. But at the end of the day, one will have to lose. I sincerely hope that after this case has been heard and the decision given, that there may be some clarity given to innocent persons who may have lost their property in a manner in which Mr. Price seems to have lost his property initially.
Let me interrupt you at the beginning here, Counsel. Is there a compensation provision somewhere?
No, sir. No, sir.
Okay.
No, sir. And if I could say, as regards Ms. Jeboo, nobody knows where she is.
Right.
We have not been able to serve her. I don't think Mr. Narayan has been able to serve this notice of appeal on her. She's like a ninja after coming off the prison. We don't know her. We don't know what she looks like. And so that's the position with her.
Okay, thanks.
Your Honor, I would like to deal, first of all, with the question of the power of attorney being void ab initio. My sincere apologies, Your Honor, for only last Friday to have submitted two authorities to the court. My sincere apologies for that, Your Honor. But the aspect with the power of attorney was that it was not that Mr. Price was out of the country. The fact accepted by both sides was that this power of attorney was forged. There's no doubt about that. So it is our submission that a criminal act of forgery made the power of attorney void ab initio. Anything done in consequence of it is of no legal effect, and as a result, the transport issued to the appellant was also of no legal effect.
Counsel, with the greatest of respect, I think you know better than that. You know better than that. The case is going all the way back, tell you that even under a void document, not void voidable, but void ab initio, once you get on the register, that separates the voidness of the action from the fact that there is no a status conferred by being on the register, which is why it has been called an indefeasible title, subject to being defeated by the exceptions. So my suggestion to you, you are getting nowhere by flogging the fact that it is void ab initio. It is void ab initio. It is a forgery. The question now is the impact of registration and the protection given by registration.
Your Honor, my respectful submission is that with the registration, the aspect is whether Mrs. Todd has been privy to the acts of fraud by Jeboo. And, Your Honor, these are the points that one needs to bear in mind. On the first visit to the property, Your Honor, she said she had the power of attorney. And
Mr. Yasin, before you start to particularize, for my benefit, could you just, in your own words, just tell me what do you think being privy to the fraud means? Just ordinary language.
Yeah.
Party two, I think do you agree? Maybe let me ask something first. The president stated it as a sort of rhetorical position, but maybe we should ask you to just clarify. Do you agree that this is not a case of Todd being a party to the fraud? There are two things under this section, party and privy, correct?
Indeed,
Do you agree before us that this is not a case of Todd being party to the fraud?
I will agree, Your Honor. There's no evidence about that.
Good. So the only possible case is whether or not, as you have put it, was Todd privy to the fraud. Agreed?
Agreed, Your Honor.
Good.
Good.
What, in your own understanding, does this mean? Not the particulars of the evidence that may demonstrate it, but what does privy to the fraud mean in your understanding of the law and the statute?
My understanding, sir, is that if I could use the word the blind eye, having begun to negotiate, having looked at the documents, having visited, there are certain things that would have raised her eyebrows or made her think twice. And once those facts are there, and those facts are of such a nature that it would make a person think twice that something is wrong and still proceed, then it is my learned contention that that would be privy.
All right, now let me just ask a follow-up question. It has to do with burden of proof and standard of proof. So fraud is, in the scale of things, you can have negligence, duty of care, balance of probabilities. Fraud we speak about often as being sort of quasi-criminal. So would you say on the burden of proof question that the burden of proving fraud was on your client?
I would say yes, on the balance of probabilities.
The one who alleges must prove.
I would agree with that, Your Honor.
Good. Two, what would you say is the relevant standard of proof for fraud, as in a case such as this?
Well, this is a civil case, Your Honor. So the standard of proof would be the proof in a civil matter on a balance of probabilities.
Okay, that's what you say. All right, fine, that's okay. I just want to know what your position is.
Thank you, Your Honor.
You realize, of course, that there are very strong statements which, in relation to fraud, qualify that balance of probability. And I think the proposition is, so as the allegation is grave, so must the facts be grave.
Point taken, Your Honor. Point taken, Your Honor.
Okay, good.
Your Honor.
Do continue.
Yeah, thank you. The facts that should have raised the appellant's eyebrow or made her beware are briefly, Your Honor, these following facts. When she went...
I'm sorry to disturb you again, but I just want to proceed on this very carefully from my point of view. Because we have to discover, we just can't go off, in my opinion, on a sort of frolic of our own. We need to anchor this in what is the fraud. Because you can have many, many facts which may be of an ambiguous nature, but I think they all have to be grounded in and or linked back to the fraud, correct?
Yes, but privy to the fraud.
Right, so because it says privy to the fraud.
Indeed, Your Honor.
So you articulate for me, for us, what was or is the fraud in this case?
So the fraud I don't understand what you mean by the fraud in this case.
All right, it says that you must be a party to the fraud or privy to the fraud.
Right.
Right, so therefore we need, I would think, to come within the statute to identify the elements. And one of the elements, we are dwelling on the privy to. And you said privy to is, in your expression, that means the blind eye. Certain things that would have made her think twice. We did BOP and the standard of proof, great. But the section is not just privy to, it's privy to the fraud.
Indeed,
so before we talk about privy to, I'm just asking you to clarify what, in your opinion, in your submission to us, is the fraud in this case.
There are several facts which I wish to point out are, when one looks at them, the cumulative effect would lead one to the conclusion that she was in fact privy to the fraud.
No.
But you're not answering my question.
Right. And I'm waiting, I'm holding my breath actually until I'm speaking.
I will leave it to my senior and better Justice Barrow to continue this course of interrogation with you, Mr. Yassin, but yes. I also am waiting for a clear answer.
And that's all I am doing, following my brother's lead. What is the fraud?
The fraud is that she knew that the power of attorney was fraudulent, and she should have known that it was fraudulent.
No, with respect, that cannot be the fact, logically. Her knowing is what would make her privy.
Indeed.
But what is the fraud? Your opponent submitted that the fraud is the forging of the power of attorney and the consequence, the action of disposing of the property on the basis of that forged power of attorney. So the fraud was the forging of the power of attorney. In the same way how, if she had signed the transport itself, or the documents leading to the transport that would be signed by an owner, that forging of the transport would have been the fraud. So
the fact is, Your Honor, is the fraud is the forgery.
Right.
Of the power of attorney.
Of the power of attorney. That is the fraud. But
so that is it then that what we must interrogate is whether Todd was privy to that fraud.
Indeed, sir.
All right. Good. Thank you.
And my submissions is when one look at the points and the facts that occurred, one should come to that conclusion that she was privy. And if I can just enumerate briefly, Your Honor, the factors which would lead one to that conclusion. The power of attorney, Your Honor, has the address of Mr. Price as 153 Crown Street.
If I may pay tribute to you, Counsel, I think you summarized all the facts beginning at paragraph 9 of your submissions, page 702 of the record, and you go 9A, 1, 2, 3, 4, 5, and then you go to 6, then you go to B, C, D, etc. So
it's there, Your Honor.
It is there. So anyone or ones you want to take us to, I think it would help us greatly if you were to identify the particular ones, or if you want to rely on all of them. I'm very comfortable with that.
I would like to rely on all of them, but I just wish to point out, Your Honor, if I can, that when she went there, the power of attorney has 153 Crown Street as the address of Mr. Price.
Right.
And going to the 152 Crown Street, it was empty, it was bushes.
Yeah.
So he could not have been living there. The law scrolls also has that. And that he could not be living there.
I put down 5 Castleton Heights, Burrell Boom, Belize District as my address. It is the fact that I'm living in Trinidad. So one uses, I also put down 1440 Coney Drive, which is my former law firm, for my address. So one uses addresses according to the convenience, according to the documentation involved, etc. So I'm just throwing these out to you because you rely so heavily on them, and I'm telling you my own response to that sort of thing.
Further to that, Counsel, is it normal that the purchaser in these circumstances would go to check the address of the donor of the power of attorney?
Well, what would have happened here, Your Honor, the power of attorney would have Mr. Price as living there. Having gone there, there's no building. There's only bush. She can't live there.
But Mr. Yassin, as important, was that an address of a property owned by Mr. Price?
Indeed, sir. Yeah. Indeed.
So that if she made an inquiry, she would have discovered that, hold on, Mr. Price has given us his address, a property that he owns.
He owned that, yes, years ago, Your Honor.
Sorry to interrupt, but President, I gather the Deputy Registrar is trying to get your attention.
Yes, thank you. Thank you, Honorable Mr. Justice Anderson. Mr. Justice Witt, Mr. Justice Burgess, there is a power outage in Barbados and he's off of the system. So he's asked that you call him, please. Thank you, Judge.
Let me see. I don't know if I can call him here.
Mr. President, may I suggest that we suspend proceedings for 5 minutes while we sort that out?
Yes, I think we better do that. So you can stay on.
Yes.
We will pause for 5 minutes. Just stay on. You can. We will put off our video and microphone and try to get in touch with Justice Burgess. So bear with us.
Very well, Your Honors. Thank you.
Yes, we are.
Yes. Let me apologize. Let me apologize profusely, but we are having some really bad weather here in Barbados, and we just had a power cut, but the power is now restored. So let me apologize to the court, you, Mr. President, and the court.
That wouldn't be necessary. Those are things that can happen, Justice Burgess. Okay, so while Mr. Yassin was breaking down the power of attorney, your power broke down in Barbados. We may continue, Mr. Yassin.
Thank you very much, sir. We have a lot of power cuts in Guyana too, sir, so you're not singular at all. Just to continue, I was pointing out those aspects in which I say that the appellant was privy. And, Your Honor, the power of attorney, although it was fraudulent at inception, that power of attorney was still being used. And every time it was being used, it is being perpetuated. And whilst it's being perpetuated, the appellant would have been privy. Your Honor, I would like to say, which the court had pointed out early on, the purchase price, 4 million, very high, very low. The valuation as submitted by the plaintiff was 12 million. A valuation submitted by the appellant was 9.2 million, still over 100%. And if you look at the last answer in the cross-examination of Mrs. Todd, she said she did not know if the property valued more than 4 million or in excess of $10 million. This answer is from a person who's the owner of several other properties. Your Honor, my learned friend, and the court asks my learned friend as regards the signature of Mr. Price. My learned friend indicated that the signature was not on the transport that the appellant had. I agree with that. But when the appellant went to the deed registry to check the transport, that transport, which has been tendered in the court as an exhibit, that transport had the signature of Mr. Price. And when one looks at that signature and compared to the power of attorney, one will see it is completely different. And so this is in the deed registry.
All right, so let's just break this down a little bit carefully, because we are trying to discover how Todd could have been privy.
Yes,
correct?
sir. Yes.
But Todd could be privy. Todd has to have notice or knowledge. Correct?
Correct.
So I'm a little unclear. You said just a moment ago, yes, it is correct that the signature of Price was not on the transport that Todd had.
Yes. That was given to her by Jeboo.
I agree. So that if it was not on what she had, how did she have notice to be privy? If she did not see, what was she turning a blind eye to?
The transport and the deed registry, when she went to the deed registry to check, that transport had the signature of Mr. Price.
And at what point did that happen in the transaction?
That was before she signed the agreement of sale.
That's after all the certifications and everything are done.
No, sir. Certification had not been done as yet.
That's the agreement. That's the agreement for sale.
That's before the agreement of sale.
So she would have seen the transport with Price's signature before she signed the agreement for sale. Is that what you're saying?
That is correct, sir.
Okay, thank you.
And that transport was tendered by the clerk from the deed registry.
But in what proximity to her seeing the signature on the transport did she see the signature on the power of attorney?
But she had the power of attorney with her. Sorry, sir. Sorry. I thought you had finished.
She had the power of attorney with her.
Yes, sir.
Is that what you're saying? Okay.
Yes. The evidence is that she was given a copy of the power of attorney. She was given a copy to transport, and she said, she did not see the signature in the transport. But
Right.
the original transport in the deed registry had the signature. And if in fact a copy was taken, then the signature had to be erased or blotted out.
No, but you would have cross-examined. This can't be a matter of speculation. Surely if this is your case, then one assumes that somewhere in the evidence it was put to Todd. When you had to sign the agreement, did you not have before you exhibit ABC or whatever it is? Look at exhibit ABC. Do you not see the signature of Price on it? Is this the document that you had? Where is the evidence? This can't be. Fraud is not something about which we can speculate. Did you cross-examine to put to her that you were privy because this is your case? When you signed, you say to us, when you signed the agreement, you had the transport with the signature. Look at this document. Is that not so? Is that in the evidence or not?
What is in, no, sir. What is in the evidence is that when she signed the agreement, she had a copy of the transport without a signature.
Well,
But
that's
when
what I was asking.
Yeah.
You told me that when she signed the agreement, I've just written it down. The signature of Price was on the transport when she had to sign the agreement.
No, sir. I said that when she went to the deed registry to make a check, that transport in the deed registry had the signature.
When did she do that?
Before she signed the agreement of sale.
Is there evidence of that?
Yes, sir. That's her evidence.
That when she went to check before, the transport she saw had his signature? Is that her evidence?
No, the evidence is not that, Your Honor.
Did you
Your
cross-examine to ask her that and
No,
put that to her?
No, Your Honor, but the evidence had been led before by the clerk from the deed registry who tendered it. And when she tendered it, it had the signature. And
But you see, your case is fraud or privy, and you have to prove, we went through burden and standard, that Todd at least had knowledge to turn the blind. Suppose she had an explanation. Suppose she said in your question to her, yes, I went there, they showed me a deed. The truth of the matter is I didn't turn the back of it. They showed me the transport and they said this is the transport. You see, if you don't put your case, we have to be careful to speculate about fraud, because when you put your case, the fairness allows the party who you are cross-examining to offer an explanation if there is one or not.
I agree with you on that.
So that is why I'm not trying to be difficult. I'm just trying to understand, because we are dealing with the proof of fraud. As our brother has said, where the allegation is grave, as is forgery of a deed, so must the proof be. And you agreed with that?
I agree with that, Your Honor.
All right. Let's move along.
Yes, Your Honor. The other aspect I wish to bring to the court's attention, Your Honor.
Sorry, Counsel, before we move along, it is a factor which will detain me, and therefore I want to give you the opportunity of setting me right on the point.
Grateful, Your Honor.
I have looked many times in private practice at different documents, etc. And I can tell you the instances in which I have bothered to compare the signature on one document in relation to another document, the instances are very, very, very few. Because I would expect, unless I'm looking out for a forgery, why would I look at the signature? This document is registered. It is notarized as having been properly executed before a solemn official of the system. Why would I look to compare the signature? And I'm really very deeply rooted in that inquiry.
The reason why she should have looked, Your Honor, was before she went to the deed registry, she went to check on the property. And having checked on the property, she would have seen it was bushes. And
Yes.
Mr. Price could not have been living there.
Yes.
So having seen that, should have alerted her to something. And so having gone to the registry, especially when it is a power of attorney, she should have looked.
With the greatest of respect, that is entirely, there's no connection between the two things except your desire to connect them. You are saying that the fact that this man did not live at the address given in a document, when everybody knew he did not live at any address in Guyana because he was living in the States, that should have alerted her to something. With the greatest of respect, I don't see that. But even more so, even if she should have said, well, wrong address he has given, does that mean then that the next step is to suspect that the document in the registry, solemnly executed and attested, etc., may be a forgery? You need to convince me, because I'm telling you, I'm not convinced.
Mr. Yassin, I share my brother's concerns, because I was careful to ask you, we have to connect this to the fraud. That is to say, the fraudulent power of attorney.
See, Your Honor, I understand the difficulty that the respondent had and still has, is that when a fraud is being perpetuated, it is hidden. Nothing is open about it. And the only way one could attack it in court is by trying to look at the circumstances to see where the accumulation of them may lead to the conclusion of fraud or privy. Because when a criminal and a forger is going to forge something, it's not going to publicize it, right? And so the only way I or the court could look is to look at
Mr. Yassin, were you presented with that same problem of proven fraud in respect of Ms. Jeboo?
No, Your Honor, because she had pleaded guilty.
Yeah, yes, I must confess I'm having a little difficulty as well in following your line of reasoning as regards, as you call it, circumstantial evidence proving participation or privy in the case of Ms. Todd.
But Mr. Yassin, the police investigated both of this whole incident.
Indeed, sir.
Did you subpoena the police investigations or the officer? You come in to prove fraud on Todd? First of all, you accept you never pleaded fraud against Todd. The reply, nowhere. Agreed? Even in the affidavits in support of the injunction, there's no allegation. So you alleged against one fraud and against the other negligence.
Indeed.
Agreed?
Agreed.
Right. That was after the police or before the police investigation?
That was after the police investigation.
Correct.
No, Mrs. Todd, the appellant, was never charged.
No. Your case, your civil case, followed the police investigation, correct?
Indeed.
Right. All right. So you had the benefit of all of that investigative work. You chose to set out a case which says clearly, look, you, Jeboo, were fraudulent. You, Todd, your complicity, if anything, was negligent. Well, you are trying now to tell us that even then, when you did not think you had the evidence to prove fraud because you didn't plead it, now inferentially, as you persuaded the Court of Appeal, and I give you a lot of credit for that, that was no doubt very skillful on your part. Maybe because there are 5 of us, it may require more skill, I don't know. But the point is that skill apart, I am struggling, to be honest, to find how can there be, where is the evidence of that Todd knew, let's just say knew, or had noticed that Jeboo was doing something fraudulent. I'm not going to rehearse the facts. Going to see that the land was in bush, she was buying vacant land. What's wrong with that? That's what she was buying. So that wouldn't put her on notice. He's not there. That wouldn't put her on notice. That's unsurprising because everybody knows he's in the States. In fact, Jeboo told him, that's my uncle, he living in the States, I'm selling his land. He have a piece of vacant land, I want to sell it. So why when she goes and she sees it, suppose she saw a house, then she may be put on notice. What about this? Should put any, let us use an objective test. A reasonable, prudent purchaser, correct? Why would a reasonable and prudent purchaser become suspicious if I'm buying vacant land from somebody who doesn't live in Guyana through a power of attorney, which on the face of it is a valid document? And you go and you see land and it's covered in bush. Well, that's exactly what you're expecting to see. How? I must confess I am struggling, but maybe let me not say anything more and allow you to press on.
Thank you very much, Your Honor. Your Honor,
maybe Mr. Yassin, you can round off because the House has to speak too.
Yeah. Your Honor, I'd just like to bring to the court's attention the power of attorney. And my contention is that the power of attorney, and in fact, Your Honor, I was looking at this only on Sunday night. I have read this power of attorney dozens and dozens of times. And the point I wish to make here never crossed my mind. It was only on Sunday night when I looked at it. And I'm certain Your Honors would have looked at documents several times and never, pinpointed certain things. The power of attorney, Your Honor, has the power, and that is found at page 669 of the record, Your Honor. If I may read it, Your Honor.
Yes.
The power of attorney has to take control of, to upkeep and take possession of property situate at Lot 153 Crown Street, Queenstown, Georgetown, Demerara, without the building and erections thereon. But Your Honor, the description in the transport is a complete different description. The transport, Your Honor, is found at page 671 of the record.
Yeah.
It reads, the west half of lot numbered 153, Queenstown Ward, in the county of Demerara, Republic of Guyana, with the buildings and erections thereon. It's a complete different description, Your Honor.
Counsel, isn't this a rehearing? Or do you want us to rehear the matter? Or are you responding to an appeal? The Supreme Court having made a decision and the Court of Appeal having made a decision. Are we now to look at the evidence afresh?
Well, the court can look at it also, Your Honor, because my contention is the power of attorney was bad and didn't have the power to vest this property.
Mr. Yassin, first of all, you are not a good comparator in relation to Todd. And you only discovered this after 2 hearings on Sunday. Today is Tuesday. And you are saying that we should ascribe to Todd what took you 16 plus years to discover 2 days ago and ascribe to her sufficient sight to make a privy to fraud. You didn't even see this until 16 years plus. Unless you're asking, and Justice Burgess has rightly said, we can't reopen this case to declare something about the power of attorney. This is about privy to fraud that it took you 16 plus years to see for the first time on Sunday in an enlightened moment. We want to ask you when and where.
Your Honor, I wasn't involved in all the 16 years, sir. Counsel, there's another counsel who did the pleadings in this matter. Your Honor, just to conclude, I wish to refer to the case of Ramkisoon, case from this court, the CCJ, number 2 of 2010. And just to leave this here at paragraphs 38 and 39. And paragraph 39, if I could read paragraph 39, which is very brief. This court agrees with this last conclusion and the reasoning which supports it. They seem logical and inescapable, but we are not prepared to rule in the same absolute and unqualified manner as the Court of Appeal did, that under the proviso, a transport cannot be held to be void ab initio. In some instances of common law fraud, for example, depending on the circumstances, that might indeed be the case. My last submission of this, Your Honor, is that the transport obtained by the appellant was void ab initio. And this court has...
Sorry, Counselor, I didn't mean to interrupt on your last sentence, but based on my observations, I just wanted to ask, are you, would you say that you are a practitioner of some years standing in this field in Guyana in relation to real estate, transport of titles and so on? Is this one of your areas? Yes. Yeah, because I'm interested in something which was raised before, and I want to come back to it once more. As you said, we are faced really with two innocent persons, and one will invariably suffer. And I wanted to find out from you, and this is not directly connected to this litigation, but what's the best way do you see that we could avoid something like this in the future? Is it that the person who does the notarizing of the documents may be the locus of some kind of action? Is it what my brother suggested in terms of having some compensation fund which could respond to this? Can you think of anything that could help us going forward?
Well, Your Honor, the notary public who the deputy registrar is no longer wrong. He's deceased.
No, I'm not talking about this case.
I understand, sir. I understand.
Yes.
It's difficult because to have a fund, it will have to be the government will have to set up a fund.
Yes.
And difficult for governments to want to put money aside for something like this.
Yes.
Vigilance, much more vigilance, much more checking of the records. And when we spoke about the certificate of compliance from the Guyana Revenue Authority, they're not concerned with the accuracy and legitimacy of documents. They're only concerned with the collection of any taxes that are outstanding. So difficult, Your Honor.
Could I ask you, what about a technological kind of solution? Because we have a situation where the transport was advertised to be passed, and over a period of time. There are lots of opportunities, I believe, in technology to create apps and whatever else, where once it's advertised, some communication could be made to the owner of the property, I imagine. I'm just wondering whether something like that could not be thought about. What do you think?
That could be one, and it will be the onus on each owner to make sure that their address is up to date.
Yes. Well, I'm glad we're going to come to Mr. Houston next, because he's a youngster who is very much up in technology, and he might see a business opportunity in this field, Mr. Houston.
Yes, sir. Mr. Houston.
Okay, thank you, Mr. Yassin. Mr. Houston.
May it please your honors, I appreciate the opportunity to address this honorable court this morning. And I'm also glad that the president of the court has indicated that I do not necessarily need to take all the time allotted. I will therefore answer the question raised by the Honorable Justice Anderson. In relation to a solution, on the 1st of July 2019, the Registrar of Deeds sought to issue a notice requiring that all powers of attorney, deeds of gifts, and all other miscellaneous documents should be supported by the identification documents of the person who would have signed prior to filing. Parties from the Bar Association, and I will have to put on that particular hat myself, and the Secretary of the Bar Association sought and obtained a writ of certiorari quashing that decision of the Registrar of Deeds for the simple reason that it was not authorized by the Deeds Registry Act. The solution, therefore, rests in an amendment to the Deeds Registry Act or the rules of the Deeds Registry, requiring the production of identification documents with the filing of these types of deeds. So that was an approach to a solution, requiring color copies, which increased the cost of filing the documents, but that was part of it. So that is in relation to a solution that was advanced. I happen to be the party in the litigation on behalf of the bar who challenged and obtained a writ of certiorari. So it's necessary for an amendment to the Deeds Registry Act to occur for these requirements to be put in place.
The technological solution I had in mind, I think is quite different.
I understand that, but I was answering your first.
Yes, okay.
In relation to what can be done or what was done. So yes, there was something done, but I challenged it and successfully. But there is an attempt to address it. Appreciating that there could also be a technological solution too, wherein some form of notification, and as with electronic filing of documents, you'll have to get an electronic address to communicate with the owner or the parties filing. And that form of notification will have to happen. But because the register is old, and in the circumstances of the case at bar, we're dealing with property that has been existing for some time, that contact information may not be possible. But that is also
it would be the response. Sorry to interrupt, Council, but it would be the responsibility of the property owner to keep his or her address up to date. It occurs to me that the safeguard, and somebody mentioned that earlier, of publishing the advertisements has limited utility, because if somebody's living outside Guyana, they're not going to see in the newspapers. So to me, a practical solution would be to find a way of communicating the fact that the property is about to be transferred to somebody else to the owner. And in this day and age in which we live, I think it's just ridiculous that we're relying upon newspaper advertisements when people are living in Russia and in China and in Zimbabwe and so on. It doesn't make any sense to me.
Well, Your Honor, this court in Kwang versus Yorkie indicated the failure of notice in the official gazette to constitute actual notice to a particular party. So there is clearly a need for the advancement of the manner in which notice can occur. In moving forward, I just wanted to identify some of the dicta of this honorable court, particularly in Kwang and Yorkie, which suggested that fraud is not set in stone, so to speak, and there's a general appreciation that the circumstances of fraud may change. And that's referred to at paragraph 27 of Kwang versus Yorkie. But more importantly and relevant to this case, the case at bar, and I'm glad that the Honorable Justice Witt foresaw where I may have been going, because as I said, he would have limited my time. He would have condensed my time, was what we're talking about, shutting one's eyes or blind eye knowledge. Actually, in Kwang versus Yorkie, this honorable court cited the South African case of Meridian Bay Restaurant and others versus Mitchell, and identified paragraph 17. Now, I apologize for not identifying specifically the other paragraph from Meridian Bay, which supports the case of the respondent. Now, the honorable court has indicated certain concerns regarding the way in which the appellant should have opened her eyes. but at paragraph 18 of Meridian Bay, and I know the court would have been familiar with it, the court spoke to the earlier dicta in another South African case, Grant versus Stone Street, and forgive me for not giving the exact citation, but I can provide that if necessary. And it says this: the acquirer of the real right does not need to have actual knowledge of B's prior right. And in doing so, I'm answering the submissions on the part of the appellant. It suffices that C subjectively foresaw the possibility of the existence of B's personal right, but proceeded with the acquisition of the real right regardless of its consequences, of the consequences to B's prior right. The reference to dolus invitualis in Van Heerden's AJA's judgment echoes what was said by Oglive Thompson in Grant versus Stone Street. Although unlike the English law, the doctrine of constructive notice has in our law little or no application, it inquires of this, and they cite Erasmus Dutoit, 1910, TPD 1037, Signon versus Mugglestone, 1935, and the statement by Burstow J. in Erasmus, that if a person willfully shuts his eyes and declines to see what is perfectly obvious, he must be held to have actual notice. And this and I'm adding this, but this appears to be as sound in principle and to merit the approval of this court. In this case, we have a person who says they would have been dealing with so many business transactions over so many years, but then my learned friend called it a steal, but sometimes a deal is too good to be true. And this is one of these instances.
That depends on whose view that is, counsel. That is so entirely subjective and so variable.
Well, you see, but this one, yes, it is subjective, but that is part of what we're looking at.
So the question is, and the authorities that you cited support that point. There has to be the subjective element of something to which your subjective attention has been drawn and which you decide, I will not look that way.
And what, as my learned senior has suggested, and I note Justice Jamadar indicated that we have to be a little more, well, I wouldn't say creative, but our arguments have to be stronger or more convincing, would be that the cumulative nature of the overall conduct and everything that would have occurred in this case would have been sufficient to require the appellant to open her eyes.
Counsel, I will wish you well with that submission, because if the individual things are in so many instances meaningless, to put them together really does not give them cumulatively any greater force than what the individual merits combined can produce. So there has to be merit before there's a cumulative effect. And I do not see any merit in so many of the things which are listed in your submissions.
Mr. Fusti, I just want to clarify for myself your test. And you say, again, I'm going to try, and this is for feedback from you, that if a person, so this is your blind eye knowledge, or what you call shutting one's eyes, right? And the way you framed it was, if a person willfully shuts their eyes and chooses not to see what is perfectly obvious, you stand by that as a summary of your test?
That is the test, sir.
So therefore, no, I'm not disputing it. I just want to make sure that we're on the same page.
Yes,
good.
I do stand by that.
Good. So it must be something that is, to use your language, perfectly obvious.
Yes.
That is to say, the fraud. What is it in this case? What is it that must be perfectly obvious? What is it? What is the thing? One is shutting one's eyes to what? Privy to fraud. One is shutting one's eyes to fraud, so as not to see what is the what is perfectly obvious, the fraud. Agreed?
Yes.
All right.
Yes.
So
Yes,
that
sir.
we have to determine whether on the evidence it was perfectly obvious that Todd objectively would have known and shut her eyes to this fraud.
Yes.
Okay, good, fair enough. Thank you.
So on what basis was it perfectly obvious then?
As Learned Senior would have indicated, we start with and I respect the observation of the Honorable Court regarding the description of the property. We look at the discrepancy in the valuation and the other facts which have revealed themselves, in which my Learned Senior has alluded to. But I highlight the power and particularly the discrepancy in the valuation. And to, sorry.
No, please go ahead. Sorry.
And to indicate that Leonard Friend said that the prevalence of forged powers, the forged powers are not prevalent in Guyana. As a matter of fact, that is the latest racket. And there was actually a report in the newspaper of someone trying to sell a property, and they were caught in a sting operation at a lawyer's office using a forged power. So it's not, the matters may not have reached to the apex court, but this is prevalent. But sorry,
of course, the evidence must be it was prevalent in 2004, right? Not now, because Todd would have been privy in 2004. So there must be evidence that fraudulent powers were prevalent in 2004. This case is a 2004 transaction.
Accepted, Your Honor.
So you also accept, as I understand it, that because that is the Roman Dutch law, that there could be either actual knowledge, there could be blind eyes knowledge, which you described. There can be constructive knowledge, but a notice, but that is not part of Roman Dutch law. That takes it too far, because then you get in the realm of equitable interests, and you don't have equitable interest in connection with immovables in Guyana. Would you agree with that?
Your Honor, I will, because the construct of, I was waiting, forgive me for using this anecdote, but we know that anyone with experience in the South African context of their legal system, it is suggested that the approach of law in South Africa was replicating the Boer War, in the sense that everything English was challenged in the South African legal system. So you're living in an opposite world. And I came across that when I actually studied in South Africa. So the fact that we are dealing with the notion of constructive notice does not mean that the conduct is not recognized under the laws of South Africa. And I did not, Your Honor alluded to the fact, or the other thing, because the other element, and my Dutch is bad, my Dutch is terrible, and my Spanish is even worse. But Your Honor alluded to it in your earlier observation, because what constitutes actual knowledge or actual notice, and the words notice and knowledge are used at times interchangeably.
Yes.
But and you see in brackets when they speak of the concept of actual notice. I am missing my page, but Your Honor alluded to the other concept, and they said, or perhaps dolus individualis. And dolus individualis may be subject to diving deeper, an opportunity, and there is a debate in the context of South Africa as to the extent to which that form of notice will be recognized. But it does not mean that the conduct will not be addressed by the Roman Dutch system. So the answer is yes, but not with the label, as Your Honor has consistently said in Rampisoon and as recently as Singh and Mosai, not with the label of constructive notice. But it doesn't mean, I had a thing in my speaking notes, people are the same wherever you go, and the legal system must regard and take cognizance of unjust and unlawful conduct wherever it occurs. And the Honorable Court has identified the link between gross negligence and the requirements for actual notice by the Honorable Justice Jamadar, indicating that constant word, obvious. Because for the gross negligence, it's closing one's eye to obvious risks. And perfectly obvious is the word that is utilized. If those are all the matters that I would like to raise, save to make an observation regarding the chronological elucidation or clarification of the jurisprudence of this Honorable Court. My learned friend has been referring to cases decided in 2010, Rampisoon and Funky Fong. Meridian Bay was 2011, but this Honorable Court, particularly in Kwang versus Yorkie, paragraphs 40 to 42, expanded this concept of notice and has traced the evolution of the law of South Africa in that regard. And I humbly submit that this is an appropriate case for that extension to be held. I formally conclude by requesting whether I can be of any further assistance to this Honorable Court.
Thank you. I'm sure you could be of further assistance, but I think we are clear about your opinion, so your submissions. So I think we can go to Mr. Narayan if he wants to reply.
Thank you, Your Honor.
And replies are always short, you know that.
Thank you very much, Your Honors. Just 3 points very briefly. I will deal with the last point firstly. Your Honors, in Kwang and Yorkie, this court found that there was actual notice on the part of Millicent. The court found that there was actual notice that Yorkie had entered into an agreement of sale, that he had paid monies, that he was in possession, and that he had expended monies to do renovations. So it wasn't, the concept of notice was not expanded. The court was faced with a situation where there was actual notice. That's my first point. My second point, Your Honor, relates to a clearing up of a misconception that may have been created by Mr. Yassin, with all due respect. Your Honors, when a search is conducted at the deeds registry, as in this case, the evidence is that Ms. Todd went to the deeds registry with a copy of the power of attorney and transport given to her. How a search is conducted is that those documents are then handed to a staff at the deeds registry with a request to, listen, can you check the validity of these documents? That is the power of attorney, that it has not been revoked or anything like that, or the power has not been substituted to a third party. And in relation to the transport, can you check, see if it's a genuine transport? Can you check, see if there are any registered interests and encumbrances or leases? And can you check to see if there's any pending transfer to any third party? The registry staff goes to their original folio or their register, and they would double check. They would then come back and say, yes, everything is okay. The power is okay. It has not been revoked or substituted. The transport, there are no registered interests, leases, or encumbrances. There's no pending transfer, and it is a genuine copy of what we have. At no time is the person who's doing the search, as in this case, Ms. Todd, given the opportunity of examining that original transport in the record of the deeds registry so that she would have had any opportunity to see the signature of Allan Price. That is not done. So I just want to make that clear, that at no time would have Ms. Todd had the opportunity of inspecting that original transport in the registry. If requested specifically to do so, the registrar of deeds would facilitate it. But again, those circumstances only arise if you find something suspicious, if you are going forward, making further inquiries. And so that is the second point. And the third point is in relation to the question that was raised by Justice Anderson as to what can be done to prevent this reoccurrence in the future. Well, Your Honors, under our Land Registry Act, the legislature created what is called an assurance fund. And every time a transaction is filed and registrar fees and stamp duties is paid, a fixed percentage out of that sum goes into this assurance fund and is placed in an interest-bearing account. And the purpose of that fund, as specified in the very Land Registry Act, is that if anybody loses an interest in a property as a result of the infeasibility of title, they can then approach the registrar of lands through an application for compensation out of that fund. So maybe the legislature ought to think of something along that nature in regard to transported properties as well, which is governed by the Deeds Registry Act.
And just Mr. Narayan, that is something which is common in all RPO in Trinidad. That is so, that assurance and compensation scheme, that's a standard feature of what is called the torrent system.
Correct, that is correct, Your Honor.
And
so I think maybe
from what you are saying, that is already there in Guyana, albeit in relation to the torrents.
Not really.
Registered land, right? Yeah.
But it could similarly, the Deeds Registry Act could be amended. Right.
Absolutely. Yeah. I'm just saying it is there for sure in Trinidad, it's there in New Zealand, it's there in Australia, and wherever the torrent system is. That's something that is well established. And it is for the exact function that we are speaking about. The system understands that because you want to create indefeasibility, and indefeasibility is the prime objective of this new land registration system. It recognizes that there can be situations where you can have innocent loss. And therefore, the assurance fund with the opportunity for compensation is to preserve indefeasibility and certainty of land transactions, but at the same time, provide for compensation in just circumstances.
Mr. President, through you, sorry, are you finished, Mr. Narayan?
It was just one further point
Yes.
I was going to say as another suggestion, because I gathered that the court is looking to make certain, perhaps some comment on things that could be done to avoid this in the future. This is also a recommendation which I personally have made to the powers that be, that the Notaries Act of Guyana should be amended to create stiffer penalties or create penalties for those who betray the trust and the oath bestowed upon them, or those who are negligent in the performance of those functions. At present, the notaries do these things occasionally, and they get away with it. Their licenses are not revoked. Their licenses are not even required to be renewed, as how it is done elsewhere. So all of these things have to be reconsidered. Thank you so much, Your Honor, for your time.
Yeah, of course, a notary under the common law system is a different kind of notary than under the Roman Dutch system or in the civil law. Anyway, those are very high qualified lawyers, notaries in the Dutch system, in the Roman Dutch or civil law system. I don't think that is the case with notaries in the common law system. So you inherited this, but the form in which you inherited it is has less guarantees than it would have under the original Roman Dutch system. But anyway, I take your point, Justice Anderson.
I wanted through you to ask Mr. Yassin to respond to the second point made by Mr. Narayan. As regards the opportunity to compare the signature on the power of attorney with the transport in the registry? Because unless I'm wrong, you led us to believe, and you said you're an experienced practitioner in this field, that there would have been an opportunity on Ms. Todd and Mrs. Todd to examine the two signatures. Would you want to clarify, sir?
Yes, sir. If the request is being made by the person checking to have a look at the register.
With respect, counsel, you didn't say that. Unless I'm misunderstanding what you said. I was led to believe that on approaching the registry, Mrs. Todd, with the power of attorney and the signature thereon, would have had an opportunity to compare that signature with the signature on the transport. Was that not the impression that you were trying to give the court, Mr. Yassin?
Yes, sir, but
would you not agree that in light of what your opposing counsel has said, you owe an apology to the court?
I do, sir, but the position is, sir.
You offer that apology, sir, so we can move on?
I apologize, sir.
Thank you. And in future, Mr. Yassin, please don't do this. I don't appreciate this at all. You know, I would want to be able to rely on the representations made by counsel, especially counsel who are seasoned in the area and who are senior. Thank you very much.
Your Honor?
Yes.
If I may?
Yes.
There are ways in which this can actually occur. And there's a provision in the rules of the deeds registry rules which says that on the passing of a transport, the registrar of deeds can require a signature on the part of the person receiving title. And in receiving that title, you will have to sign the transport.
Mr. Husti, you know, thank you for the explanation. I don't want to cut you short, but let us stay in the context. Let us stay in the context of this case.
Well, no,
this submission was made in the context, and that is why our brother, Justice Anderson, is properly concerned, if not aggrieved, justifiably so, because the context was that Todd would have had notice and therefore been privy because, as a matter of course, she would have seen a signature and therefore should have compared it with the power of attorney, however realistic that may or may not have been, and therefore have turned a blind eye. So that's a very different context from a context in which you are explaining that there is a power upon request to see in certain circumstances. So thank you for the explanation, but I think we need to just remind ourselves of the context in which Mr. Yassin's submission was made. And if it is conceded that in the ordinary course, what Mr. Narayan described is what happens, then the bottom line is she would have had no notice, no opportunity to see the signature, and therefore no notice on that submission.
Well, I was actually clarifying it from the law to the actual practice, sir.
Yes, but you would agree what Justice Jamandar said. Okay.
I think, Chairman, it would be in everybody's interest for us to move off this point. Thank you very much.
Yes. Well, anyway, we have to move off from the matter because I think we have heard all of you. I think we have a clear picture of the submissions, and in due time we will give a decision, hopefully within 3 months, but you will get a notification. Madam Deputy Registrar, could you finish the case?
Most grateful, Your Honors. Thank you very much.
Thank you.
It was a pleasure.
Thank you. Thank you, Honorable Mr. Justice Witt. Thank you, Honorable Judges. Thank you, Counsel, and thank you, staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all.